between you and I, that was not that bad.
Sorry.
Because you can just, you can kind of say anything you want to say, right? Like, so that's kind of why I did a little bit of a script. Right? But I can tell you, so let's kind of review how you quickly talked about it. Here's some of the things that were good that may seem like if someone's watching that transcript, like, Alistair did a really good job. That guy's got nothing, blah, blah. But the truth of the matter is, here's a couple things we've got, right? I now know, at least today, you have no evidence that that's not your signature, right? I now know that it's an employment contract that you've effectively agreed to. And probably the best thing that we just got was, up until the time you say that this somewhat will suggest is a phantom meeting, you've agreed that 3 weeks severance was your severance, right? So that's something very good, because now I've also solidified that you really have no evidence of this agreement. If Bob now shows up and says, I never had that conversation, you've committed to that. You can't later say, oh, maybe there was no conversation. So I've asked you repeatedly about the same thing. And so we didn't talk about this in the preamble, but this is where being honest is much better, because you can see how you kind of went down this road of this meeting, and was there any evidence of it? Why didn't you send an email? And you kind of say what, honestly, it's very accurate what people say. I don't know, and like, whatever. It's like, he's a bad guy, so I don't trust him, and bad company. It's like, but that, that is something that you could, so let's say we did this for a full day or half a day. You'd probably say that 10 more times. And so you could then use that as evidence of being argumentative in court, or unrealistic or unreasonable answers, because those are not real answers, right? They're not answers to the question. They're just like, they're bad, I'm good, they've done everything wrong. So out of that whole thing, like I said, the thing that I have to say, honestly, the thing about the signature, I've never heard that before. That's an unusual thing for people to say, that I just changed mine willy-nilly and I don't recognize it's mine. But the truth is, that becomes relatively obvious relatively quickly what kind of witness, to myself and to the court. Now, if you said that to the court, they would be like, you'd just be done. Your credibility would be over. But now, if at court you went and said, yeah, that's my signature, as a lawyer, I might pull out that little transcript we just had about, oh yeah, I don't know, I changed it 10 times, and that's really bad for your credibility. So although it might feel good to be a jerk to a lawyer, and I'm sure it does to a certain degree, it's really detrimental, because you've now committed to what I would suggest is a ridiculous answer. And if you try and fix that, because now you're in front of the judge and you got your suit on and you're all like ready to go, I just go, hey, remember that time I asked you under oath? Was that your signature? And you said, I changed it 10 or 12 times and I don't really know. The judge is going to look at you like,
yeah, you're a liar.
You're a liar. And also, you're disrespectful to the process. And guess who's the number one representative of that process? Is the judge. You know what I mean? So do you want to be disrespectful to that whole process? The other thing that was quite helpful to the case was, again, you've agreed, and it's not the best, but it's pretty good, that 3 week severance was what you had prior to this kind of bizarre meeting, right? So now we ask you these questions to court, and you either change your answer because you're like, that sounded ridiculous, and really, it's funny that the kind of the way you act is not uncommon for witnesses to act that way, because they're like, they don't like me as a lawyer, they don't want to be there, they kind of want to be disrespectful to the process and to me, and they think that these questions and these answers are kind of like making it very difficult to take the next step. And there's some truth to that. But again, it's solidified, it's under oath. You change it later because you actually, if I ask you that same question, or more likely your lawyer asks you that same question, you give this perfect little answer, like 100%, yes, I did that, and 20 years ago, and whatever it is. Let's say you put a good effort into that one. Well, you've got to live with this one as well, and your credibility is just almost shot at that point. And if you say the same thing again in court, the judge is going to be like, okay, well, Bob's going to get up there and say, I never said that to Alistair. And I would never say, I don't even have authority to say that to Alistair. And, the question I said, well, why didn't you follow it up in email? Those are all kind of reasonable things, right? Like, if I just got a raise, I'd be like, Bob, come on, it's next week, right? Like, it's next week. And this thing about severance, that makes no sense either. Why would Bob just give you, another 7-week severance? Just, especially since Bob probably can't do that stuff.
Right.
So honestly, and you did a pretty good job of, not what I expected, but a pretty good job. And to be fair, in some way, you kind of almost lost your case right there, right? Because now how do you come back from that? So it's not exactly what I thought, but it worked out pretty good.
Well, it's good that you don't know my answers, right? So
yeah, I didn't. I was like, what the heck? I've never heard of this thing with a signature. I was like, what? I just change it willy-nilly. What are you, some like hitman or something? Or like you're like witness protection? So that is a good example of an exaggerated attitude.
Right.
The other thing that was not good. So let's try and do the good one now.